So we meet again. In this subunit, we are going to discuss the common law approach to indefiniteness. So let's talk about the common law approach to indefiniteness. First, let's refresh our memories. We're talking about an issue where the material terms of the contract are not reasonably certain. Now, they might not be reasonably certain because the parties were silent about those terms, they were vague about those terms, they agreed to later agree on those terms, or they agreed to later negotiate those terms. In this unit, or in this subunit, we're going to talk about the challenge for the courts when they have to resolve an indefiniteness case. We're also going to talk about the common law approach. We're going to talk about the traditional approach of courts, and we're going to talk about the more modern approach of courts. When the courts are confronted with a contract with an indefinite material term, they have a challenge. Regardless of what approach they take, they will frustrate the intentions of the parties. Now, first, let's assume we're talking about a situation where we assume the parties have assented to the contract. They want to be bound by contract. In that case, the court, when approaching a contract with an indefinite material term, can choose to either not enforce the contract or can choose to enforce the contract and supply the material term for the parties. In either case, the court can frustrate the intentions of the parties. So if we don't enforce, if the court does not enforce the contract, it will frustrate the parties' intentions to be legally bound. And if the court supplies a term and enforces the contract, it frustrates the parties' intentions to decide the terms of the contract for themselves. All right, so now we know the challenge that's before the court. Let's talk about the possibility of supplying a term. So the court needs a basis to supply a material term. Where does that come from? Well, it may come from the language of the contract itself. Somewhere in the contract, the court might find a basis for supplying the material term. Otherwise, it can come from course of performance, course of dealing, and trade usage. We will see these terms a lot, so you should learn what they mean. Course of performance, course of dealing, and trade usage. Course of performance means the parties' conduct under this contract. So, although the contract may be uncertain with respect to a material term, maybe the parties have supplied the term themselves in conduct under this contract already. Otherwise, we could look at course of dealings. Maybe the parties have entered into similar contracts in the past, and we look at how they dealt with the missing material term in the past. Otherwise, trade usage, which is custom in the industry, might give a basis for the court to supply a material term for the parties. Let's take a look at how courts deal with silence as to a material term. The common law approach is for the courts to supply the material term if the language of the contract and/or the circumstances allow. When the parties are silent as to a material term, they never agreed to a material term, the court can engage in a little fiction. The fiction is the parties would have agreed to this term, the term I am supplying, had they thought of it. They didn't think of it, they never agreed to it, but had they thought of it, they would have agreed to this. If we engage in this little legal fiction, then we're not frustrating their intentions. Indeed, we are enforcing the contract, so we're not frustrating their intentions to be legally bound, and we're not frustrating their intentions to agree to the terms of the contract, because if they had thought of it, they would have agreed to the term that I am supplying them. Yes, it's a legal fiction, but courts are willing to engage in this legal fiction. Where can the court get a term to supply? Well, once again, we look at the language of the contract, course of performance, course of dealings, or trade usage. All right, now let's talk about vagueness. When the parties are vague with respect to a material term, the courts traditionally have been unwilling to enforce the contract and unwilling to supply the material term for the parties. So this is the basic reason. Remember when we said that the court could engage in this legal fiction when the parties were silent as to a material term? When the parties were silent as to a material term, the court could say, listen, the parties never thought of it, but had they thought of it, they would have agreed to this, and then I supply the material term. But when the parties are vague as to a material term, clearly they thought of it, right? So if they said fair price, they thought about price. And if they said reasonable duration, they thought about the duration. So it would be very disingenuous for the court to say, well, they never thought of it. And if they had thought of it, they would have agreed to this, because they clearly thought of it. All right, let's talk about the more modern approach to vagueness. The more modern approach is for courts, they're more willing to supply the material term for the parties, but only if they can find some justification. Once again, they'll look to the language of the contract, the course of performance, course of dealing, and trade usage. In other words, the more traditional approach to vagueness was to say, I'm not going to enforce this contract. This contract is unenforceable without this material term. The more modern approach is to treat it closer to the way we would treat silence, and that is supply the material term for the parties if the language of the contract gives us some sort of basis for supplying the term. If not, we can look to course of performance, course of dealing, or trade usage. All right, let's talk about what a court will do under the common law when the parties agree to a material term. The traditional approach is very much like the traditional approach to vagueness. The courts are reluctant to supply a material term, and the reasoning is the same. The court cannot say the parties did not think about this, but had they thought about it, they would have agreed to this material term, and then the court would supply the material term. The court can't engage in that legal fiction because clearly the parties did think about it. They said, we promised to agree to a price later. They thought about it. Or they said, for a reasonable for a reasonable duration, mutually agreeable to the parties. They did think about a duration. Under the more modern approach, the courts are more willing to supply the material term, right? If they can find something in the language of the contract, the course of performance, the course of dealing, or trade usage. Now, remember, let's just review this a second. Course of performance is how the parties have performed under this contract. So if there is an agreement to agree on a material term in the contract, and over the course of this contract, they've already gone through a process of agreeing to it several times, right? If it's a monthly contract or if it's an installment contract, then they've already had experience agreeing to whatever material term that they agreed to agree to, then the court can look at that and say, you know what, I've seen what you've done under this contract, and I can make you do the same thing now. And so I will supply the material term based on what you guys have already done under this contract. If the parties haven't done it under this contract, maybe they've done it under past similar contracts, and the court can look at that and say, listen, you've done this, you've dealt with this issue under past contracts, this is how you resolved it under past contracts, now I'm going to supply the material term for you based on what you've done in past contracts. Finally, trade usage might give the court some context, some basis for supplying a material term. In some instances, a court will say, listen, I don't have any basis to supply a material term, but What I'm going to do is I'm going to make you negotiate in good faith. I can't make you agree to a material term, but I can make you sit down and negotiate in good faith. And if you don't come to an agreement, I can't make you agree, but I can check to see if you have negotiated in good faith. All right, let's talk about agreements to negotiate a material term. You can see how this is significantly different from an agreement to agree. In an agreement to agree, both parties are agreeing to agree. And so when they don't agree, who's in breach? It's hard to say. An agreement to negotiate in good faith, the parties don't agree to agree, they just agree to negotiate. I'm sorry, they don't necessarily put in the contract, we promise to negotiate in good faith. But the courts have said that this promise to negotiate is implicitly a promise to negotiate in good faith. And while the court can't force the parties to come to an ultimate agreement, the court can say, listen, you breached your promise to negotiate in good faith. You just negotiated as a pretense and you weren't negotiating in good faith. Now, we've already talked about good faith in other contexts, but the definition we used for good faith in other contexts should apply here also. Good faith will normally have a subjective element. Were you honest? Right? We look and see whether you honestly believed and whether you honestly negotiated. It also has an objective element. Did you act reasonably under the circumstances? Would a reasonable person in similar circumstances have acted the same way? So this is what a court would apply to this promise to negotiate. The court would say it's a promise to negotiate in good faith, and if the other party sues you for breach, we can look to see if you were honest in your negotiations and whether you negotiated reasonably. I can't make you agree, but I can check and determine whether you negotiated in good faith.